The ayes are 308, the nays 101, 3 answering present, and the journal stands approved. Purpose, the gentleman from Indiana rise.
Mr. Speaker, I rise today to ask unanimous consent that I be removed as a co-sponsor on H.R. 3697.
Is there objection? Without objection, so ordered. What purpose does the gentleman from Missouri rise?
Mr. Speaker, I ask unanimous consent to have my name removed as co-sponsor from H.R. 3359.
Is there objection? Without objection, so ordered. What purpose does the gentle lady from Texas rise?
The Speaker, on H.Res. 591, roll call vote 119, I was detained on official business, and I would like to indicate that I would have voted no on H.Res. 591, the rule to H.R. 5. I ask unanimous consent that it be placed appropriately in the record.
Without objection, it'll so be noted.
Thank you.
What purpose does the gentleman from Michigan rise?
Mr. Speaker, I would ask unanimous consent that all members may have 5 legislative days to revise and extend their remarks on the legislation and to insert extraneous material on H.R. 5.
Is there objection? Without objection, so ordered.
Right.
Gentleman from Michigan.
Speaker, I would, we are now, if I could ask for order.
No.
So I would yield. The
gentleman from Michigan. The gentleman from Michigan.
So we're in the committee of the whole now? So,
They will go into committee of the whole.
all right, so what?
Pursuant to House Resolution 591 and Rule 18, the Chair declares the House and the Committee of the Whole on the State of the Union for the consideration of H.R. 5. The Chair appoints the gentleman from Georgia, Mr. Westworley, to preside over the Committee of the Whole.
The House is in the Committee of the Whole on the State of the Union for consideration of H.R. 5, which the clerk will report by title.
A bill to improve patient access to health care services and provide improved medical care by reducing the excessive burden the liability system places on the health care delivery system.
Pursuant to the rule, the bill is considered read the first time. General debate shall be confined to the bill and amendments specified in House Resolution 591 and shall not exceed 6 hours, equally divided among and controlled by the respective chairs and ranking minority members of the Committees on Energy and Commerce, the Judiciary Committee, and Ways and Means. The Chair recognizes the gentleman from Michigan, Mr. Upton.
Well, thank you, Mr. Speaker. I would yield myself as much time as I might consume.
And the gentleman recognized.
Mr. Speaker, I rise today in support of the PATH Act, which addresses 2 of the most glaring deficiencies of the President's overhaul of the health care system. By what it does and also by what it failed to do, the health care law threatens access to quality health care for literally millions of Americans. Section 3403 of the Affordable Care Act established the Independent Payment Advisory Board, or IPAB, a panel of 15 unelected, unaccountable bureaucrats who will be given the power to make major decisions regarding what goods and services are valuable. These decisions will then be fast-tracked, essentially bypassing the legislative process with almost no opportunity for discussion or review. The PATH Act prevents this by repealing IPAB. I suspect that most Americans still believe that patients and their doctors should have a voice and should be able to decide what health care services that they find valuable. And I think that they still believe that major policy decisions affecting the Medicare program and the health care system in general need to go through the regular legislative process and be subject to the normal system of checks and balances according to the Constitution. It is encouraging that the co-sponsors of legislation to repeal IPAB includes 20 Democrats, and that the bill was favorably reported out of the Energy and Commerce Committee earlier this month without any recorded opposition, a voice vote. I encourage my colleagues on both sides of the aisle to support repealing IPAB and not to block its passage at the expense of our seniors in a blind effort to defend the President's signature legislation. The legislation today also includes reforms that will actually lower the cost of health care, a glaring omission in the President's health care law. The health care law failed to provide any meaningful reform to the broken and costly medical liability system, which is currently one of the largest cost drivers of our health care system. The current system is responsible for as much as $200 billion a year in unnecessary spending on defensive medicine. It fails to compensate injured patients in a fair and timely manner, and it threatens access to quality health care by driving good doctors out of high-risk specialties such as obstetrics and neurosurgery. According to the CBO, these common-sense reforms will reduce the federal deficit by $48.6 billion over the next 10 years. So how have opponents proposed to fix this present system? They want to spend more. $50 million in grants for states' demonstrations, as called for in the health care law, is not a solution. It's an abdication of responsibility. The President promised to look at Republican ideas for medical liability reform. Passing this legislation is the very first step towards allowing the President to make good on that promise. So health care decisions should be made between a doctor and a patient. That relation doesn't work when bureaucrats and trial lawyers come between them. So I urge my colleagues to vote in support of this legislation, and I reserve the balance of my time.
The gentleman from California is recognized.
Mr. Chairman, I yield myself such time as I may consume.
The gentleman from California is recognized for as much time as he may consume.
Mr. Chairman, I rise in opposition to H.R. 5. It combines two very bad ideas into one terrible bill that is anti-senior, anti-consumer, and anti-health. It's no accident that we're considering the legislation during the second anniversary of the Affordable Care Act, because this is a thinly veiled partisan attempt to confuse the public and obscure the law's success in covering young people, reducing costs for seniors, and providing improved health benefits. Title I of the bill before us, the medical malpractice provisions, have been around for over a decade. They have not been enacted under Democratic or Republican Congresses and presidents because they are an extreme intrusion on the authority of the states to set their own liability rules and would shield bad actors from accountability when they cause injury and death. Let's be clear. This bill is much broader than traditional medical malpractice legislation. It protects manufacturers, distributors, suppliers, marketers, even promoters of health care products. And it gives them protection even if they intentionally cause harm. Insurance companies and HMOs are protected as well. The bill shields drug and device manufacturers with complete immunity from punitive damages, no matter how reckless their conduct, so long as their products were at one time approved by the FDA. This bill preempts state action in an area that has traditionally been left to the states. To the extent that we do have a medical malpractice problem in this country, it should be addressed at the state level. But this bill not only strips away state law, it puts in place a federal scheme that will not reduce medical errors, will not award appropriate and adequate compensation when an injury occurs, and will not lower health care costs. The second part of the bill would repeal the Independent Payment Advisory Board, or IPAB, which helps keep Medicare costs under control if they rise more than anticipated. IPAB's role is to recommend evidence-based policies to improve Medicare without harming patients. Repealing IPAB is the height of hypocrisy. The main Republican attack on Medicare and the Affordable Care Act is that we cannot afford them. House Republicans are proposing changes that would destroy Medicare because they say taking care of our seniors just costs too much. And yet today, they will vote for a bill that eliminates one of Medicare's cost-saving innovations and saddles Medicare with over $3 billion in unnecessary costs. It's no wonder that the public holds Congress in so little regard. The Republican master plan for Medicare is to end the guarantee coverage and shift more costs onto seniors and people with disabilities. They don't hold down the costs, they simply shift them on to seniors and disabled people under Medicare to pay more for it out of their own pockets. This is part of the Republican assault on Medicare. It would repeal the backstop in Medicare that keeps Medicare affordable for seniors. I want to be clear about what the IPAB is and what it isn't. The board is explicitly, in statute, prohibited from rationing. It also is prohibited from making recommendations that increase costs to seniors or cut benefits. IPAB also doesn't take away the role of Congress. IPAB makes recommendations, but Congress can and should act on those recommendations. We hear a lot about these unelected bureaucrats. Let me tell you, around this place, there are a lot of elected bureaucrats. Here's the fundamental difference between the Democratic approach to Medicare and the Republican approach. Democrats in Congress are committed to preserving Medicare and protecting seniors' benefits. Republicans have proposed ending Medicare's guarantee of coverage so they can pay for tax breaks for oil companies and millionaires. Let me underscore that. They want to take money out of Medicare so they can give more tax breaks to billionaires and oil companies. Like some of my colleagues, I have concerns about some aspects of the IPAB. I don't agree with the premise that we need IPAB to make Congress do its job, but no one should think that the hyperbole of IPAB's Republican critics, rationing, death panels, faceless bureaucrats, pulling the plug on sick patients, represents reality. That came from their propaganda word masters. House Republicans are voting to repeal the Independent Payment Advisory Board because they simply want to eliminate Medicare. They want to provide vouchers instead of benefits. They want to shift costs to the beneficiaries. They want to put Medicare into a death spiral and leave insurance companies in charge of seniors' care. Then it would be the insurance companies who could then ration care, cut benefits, and according to the congressional budget, likely increase out-of-pocket costs by $6,000. Does anybody doubt insurance companies ration care? Try to get an insurance policy if you have a previous medical condition. They won't even cover you, or they'll charge you so much you can't afford it. Is that what we want? Let the insurance companies make these decisions for our seniors and disabled people? H.R. 5 is a partisan assault on Medicare, an assault on patients who are injured by careless doctors and drug companies, and an assault on states' rights. I urge my colleagues to vote no on H.R. 5, and I reserve the balance of my time.
The gentleman from Michigan.
Mr. Speaker, I would yield 2 minutes to the Chairman Emeritus of the Energy and Commerce Committee, Mr. Barton, the gentleman from Texas. 2 minutes.
The gentleman from Texas is recognized for 2 minutes.
I thank the distinguished chairman and would ask unanimous consent to revise and extend my remarks.
Without objection, so ordered.
Thank you. We have just heard an argument from one of the authors, if not the chief author of the new health care law. So it's understandable that former Chairman Waxman would rise in indignant defense of his product and opposed to this bill. But H.R. 5, the PATH bill, is in actuality a reasoned response to an irrational attempt to socialize health care in the United States of America. The Independent Payment Advisory Board, which this legislation repeals, is an independent 15-member panel appointed by the President, unless the President doesn't appoint it, in which 3 of the President's chief advisors become the board, and if they don't decide to do it, then one person, the Secretary of Health and Human Services, has the authority, when this kicks in 2014, to make all kinds of decisions that directly impact health care in America. I don't think, and a majority of my colleagues don't think, that that's the way it should be done. So this bill, in one paragraph, I think on page 24, repeals that section. That is a good start. It is not the end-all, be-all, but it is a good start to regaining control of health care by individuals and the marketplace. The other thing this bill does is put in a medical malpractice reform that has been long overdue. The President in the State of the Union said he was for medical malpractice, but I'm told that he has said he's not for this medical malpractice. Just like he's not against the Keystone Pipeline, but he called senators to oppose it when it came up in the other body. We need medical malpractice reform. Independent observers have said that this bill that Congressman Gingrey of Georgia is the original sponsor of would save $48 billion over, I think, a 10-year period if enacted. $48 billion. That's real reform. It does not preempt states. It allows the states to continue their parts of medical malpractice that they've already enacted. So I ask that we vote for this piece of legislation and thank the chairman and the subcommittee chairman and all the members that have made it possible.
Time of the gentleman has expired. Gentleman from California.
Mr. Chairman, I'm pleased at this time to yield 3 minutes to the distinguished ranking member and soon-to-be chairman of the Health Subcommittee, gentleman from New Jersey, Mr. Pallone.
Gentleman from New Jersey is recognized for 3 minutes.
Thank you, Chairman Waxman. You know, I have a great deal of respect for my former chairman and colleague from Texas, but the problem that I listen to him is that it's always the same. It's my way or the highway. And it's just very unfortunate because there have been many opportunities in the committee where we could have worked together and come up with legislation on things like malpractice reform and IPAB, but that's not what we get from the Republican side of the aisle. They just constantly want to do their own thing, and if you, as he said, well, the President may be for malpractice reform, but if he's not for this malpractice reform, then he's a bad guy. And that's the point. We need to get together. If we're ever going to accomplish anything, we need to work together, and I don't see that happening on the Republican side of the aisle today. I'm very disappointed in the process of considering H.R. 5. I'm disappointed and frustrated that my Republican colleagues had an opportunity to bring to the floor a bill that I and some of my Democratic colleagues supported, but what they decided to do instead is to simply play political games over and over again. All sectors of the healthcare industry agree that the Independent Payment Advisory Board, IPAB, should be repealed. I'm the first one to tell you how much I'm opposed to IPAB. In fact, during the Energy and Commerce Committee Subcommittee on Health Markup, I voted in favor of its repeal. But unfortunately, my Republican colleagues have no interest in truly repealing IPAB. They only care about defacing the Affordable Care Act and continuing their political game of repealing the law piece by piece. Now, I know that because they've decided to pay for the IPAB repeal with H.R. 5, one of the most controversial and historically partisan bills of the past decade. We've been through this same debate every time, every year, H.R. 5 on the floor again. Each year the Republicans have been in charge. We're forced to consider identical legislation that contains the exact same areas in which we remain divided. In fact, the Republicans Republicans weren't even able to enact this bill into law when they had the majorities in the House and Senate and the presidency. And the reason is because they have zero desire to solve the problems of this country. All they're interested in accomplishing is a political message to take home to their districts. I've said again and again that I'd work with my colleagues on truly addressing malpractice reform, but those calls have gone unanswered. Over the years, there's been little effort on the part of Republicans to reach across the aisle and work with Democrats on a satisfactory solution to medical liability reform. I do understand that medical malpractice and liability is a very real problem for doctors in my home state and in the country, but H.R. 5 is not the answer. Any true reform must take a balanced approach and include protections for the legal rights of patients and be limited to medical malpractice. Today, my vote on this package is a no vote on H.R. 5 alone. As I've stated, it's too controversial and extreme in its current form. Although it's described as a medical malpractice measure, H.R. 5 extends far beyond the field of malpractice liability. And I'm just extremely disappointed. I'm being honest in saying I'm very disappointed that the Republican leadership has robbed many Democrats of their ability to vote cleanly on IPAB repeal and have instead, yet again, politicized this body. When will you learn? I yield back.
Time of the gentleman has expired. The gentleman from Michigan.
Mr. Speaker, I would yield 2 minutes to the gentlelady from North Carolina, the Vice Chairwoman of the Energy and Commerce Committee, Ms. Myra.
Gentlelady from North Carolina is recognized for 2 minutes.
Thank you, Mr. Chairman. Mr. Speaker, this is Washington, so we have to have an acronym for everything up here. The IPAB isn't a new techie technique, but an example of one of the many misguided parts of the budget-busting health care law. What's this debate really about? We all know that Medicare is headed toward financial catastrophe, and the health reform law only succeeded in putting the program in a more precarious position. There's no easy solution to this problem, but Republicans have put forward a plan that would actually set the program on a healthy fiscal path again without hurting those who are already on the program. Of course, because this is Washington, rather than having a hearty debate, these proposals continue to be demagogued and derided. Instead, the health reform bill gave us IPAB, an unaccountable board tasked with limiting procedures and treatments in order to control costs. It's a top-down, unconstitutional, ineffective and inefficient way to solve Medicare's fiscal problems. And if you think that this board won't make recommendations to limit the use of expensive but life-sustaining treatments, you haven't been paying attention. But here's something that gets lost in the debate. IPAB just doesn't apply to Medicare beneficiaries for seniors who are on government programs. First off, those of us who have been here for a while know that private insurers tend to follow Medicare. We see it all the time. Once Medicare changes a treatment, those decisions push private payers to also move in that direction, because so much of our health care system relies on Medicare's policies. The government already controls so much of our health care system, and that's why all these inefficiencies abound. If that weren't enough, starting in 2015, the IPAB can make decisions about what private plans will cover. Yes, 15 people will be deciding what private companies will be covering. That's what's fundamentally wrong with the health care reform law, and we should repeal the whole thing. But in the meantime, let's repeal this ill-conceived board and address the country's medical malpractice problems while we're at it.
The lady has expired. The gentleman from California.
Mr. Chairman, I'm pleased to yield to an important member of our committee, gentleman from Texas, Mr. Green, for 2 minutes.
Gentleman from Texas is recognized for 2 minutes.
Thank you, Mr. Speaker, and thank my colleague and ranking member on our Energy and Commerce Committee. I rise in opposition to this bill. I'm not as opposed to all of it. In fact, I'm a strong supporter of the repeal of the IPAB provisions. However, we can't undermine Americans' right through court placing arbitrary limits on malpractice cases. That's what this bill before us does. We shouldn't solve a bad policy problem by implementing more bad policy. We should be passing good legislation not trying to pass something that has no chance of becoming law, and that's what this bill does. The Affordable Care Act, the underlying statute of this bill amending, has had enormous positive impact to the constituents I represent. And the law is not totally even effective yet, but it's getting better. I was proud to support this landmark legislation as part of the Energy and Commerce Committee and on the Health Subcommittee. Before the passage of the Affordable Care Act, our congressional district had the largest percentage of uninsured in any district in our country. We still have a lot of work to do, but things are getting better. For the last 2 years, 53,000 children in our district can't lose the security offered by health insurance due to pre-existing conditions. 3,400 seniors are saved an average of $540 on prescription drugs. 9,000 young people now have health insurance that they didn't have before the Affordable Care Act. The Affordable Care Act was not perfect, but no bill is perfect. The bill before us today is far from perfect. I support the repeal of IPAB. I opposed IPAB in 2009 when it came up in our committee in markup of the Affordable Care Act. I do not believe a panel of outsiders appointed by the President should be take responsibilities for what Congress needs to do in making decisions on Medicare payment rates. That's part of our job as a member of Congress. However, this bill is a step too far, and I want the opportunity to vote on a freestanding IPAB repeal, but I cannot support H.R. 5 because it's a bridge too far. Thank you, and I yield back my time.
Time of the gentleman has expired. The gentleman from Michigan.
Mr. Chairman, at this point I would yield 2 minutes to the gentleman from Florida, Mr. Stearns.
Gentleman from Florida is recognized for 2 minutes.
I thank the distinguished chairman. This bill, contrary to the gentleman from Texas said, is an opportunity for him to vote, to not let bureaucrats make the decision. He has a chance to do this. I'm a little surprised why he's saying he's against the bill. Of course, I think many of us are going to repeat the same arguments. The fundamental point is that this bill will save almost $50 billion over 10 years. Now, how many people on this side don't want to save money? I think everybody on both sides of the aisle would like to save money. So this is really stopping this defensive medicine, an untold amount of litigation, by passing this bill. This could effectively create premiums for everybody and lower the cost of health care. This bill would eliminate, as pointed out, even by the gentleman from Texas, the Independent Payment Advisory Board. It's given the colloquial name of IPAB. Just this morning, as chairman of the Oversight and Investigation Committee, we held a hearing on the President's failed health care law. It's clear that countless pages of regulation, rules, requirements for Obamacare have been incredibly confusing. And when we had this hearing, it was brought up clearly that this bill, over 2 years, has given almost 1,700 waivers to entities who cannot comply with this health care bill. So my constituents and individuals throughout this country view these massive new rules and regulations as increasing interference of the federal government into their lives. And obviously business communities, they're seeking waivers. 1,700 entities asking for waivers because they can't comply. It creates uncertainty in the marketplace. So for all these reasons, we must pass this bill. In fact, IPAB is SGR on steroids. Rather than fixing the SGR problem in the health care law, Democrats are happy to allow continued cuts to physician payments and then double down on further cuts through IPAB. This is a group of 15 unelected bureaucrats who would save Medicare by making draconian cuts to provider payments. Democrats wanted to control the future costs of Medicare by giving unelected bureaucrats the power to cut payments to hospitals and to our doctors. If Democrats were serious, they would support this bill. Nancy Pelosi, the former Speaker, Minority Leader, said we have to pass this bill so you can find out what's in it. Remember that quote? I'm determined to make sure we don't have to fully implement the bill so we can see what it cost. With that, I yield back.
The gentleman has expired. The gentleman from California.
Mr. Chairman, I'm always amused when I hear people talk about government interference in our lives. If people think Medicare is an unjust government interference in their lives, they can forego their Medicare. But I don't know too many people who would like to do that. And what the Republicans are proposing is to take that Medicare away from them and turn it over to private insurance. Put that to a vote. I don't think the American people would support that either. I'm pleased at this time to yield to a very important member on our committee, especially in the Health Committee, a representative from the Virgin Islands, Ms. Christensen, for 2 minutes.
Gentlelady from the Virgin Islands is recognized for 2 minutes.
I thank you for yielding. Mr. Speaker, I rise today during a time when we should all be celebrating the many great successes of the Affordable Care Act on its second anniversary. Democrats have rightly been applauding the health and economic benefits of affordable, reliable access to high-quality health care services brought about by that landmark law. Not so with our Republican colleagues who choose to ignore or misrepresent the many benefits millions of people have been enjoying because of the Affordable Care Act. Then comes this disastrous marriage between two bills, one that will repeal the Independent Payment Advisory Board, which some Democrats like myself support, and the other malpractice bill, which I strongly oppose because it will trample states' rights, providing extraordinary protections for drug and medical device and health insurance companies, making it nearly impossible for those harmed to seek and achieve justice. I support the IPAB repeal because in its current form it will not achieve significant savings or ensure quality access to health care under Medicare. Additionally, as a physician who practiced for more than 2 decades, I'm opposed to its broad authority to make recommendations that would detrimentally affect health care providers and eventually the Medicare beneficiaries. However, attaching at the very last minute a medical malpractice bill that provides protection to every entity involved in medical malpractice and health care lawsuits except the victim is just plain wrong. And no pun intended, but adding insult to injury is the fact that their medical malpractice bill is completely outdated. The bill was designed more than 2 decades ago. Back then we did have challenges with malpractice insurance, but today those challenges have been addressed. Today we do not have a malpractice insurance crisis in this country. I strongly oppose H.R. 5 and encourage my friends on the other side of the aisle in the future, if it's more than just political rhetoric, to quit while they're ahead. Thank you, and I yield back the balance of my time.
The time of the gentlelady has expired. The gentleman from Pennsylvania.
Mr. Speaker, at this time I yield 2 minutes to the distinguished Vice Chairman of the Health Subcommittee, gentleman from Texas, Dr. Burgess.
The gentleman from Texas is recognized for 2 minutes.
I thank the Chairman for the recognition. Mr. Speaker, I will focus my remarks on the Independent Payment Advisory Board because it encompasses all that is wrong with the Affordable Care Act. The health law itself contains policies that will disrupt the practice of medicine. Along with the many excesses and constrictions within the law, the Independent Payment Advisory Board represents the very worst of the worst of what will happen. As a physician, as a member of Congress, as a father, as a husband, as a patient in his 60s, I am offended by the Independent Payment Advisory Board. This board is not accountable to any constituency, and it exists only to cut provider payments to fit a mathematically created target. The board throws the government into the middle of what should be a sacred relationship between the doctor and the patient. The doctor and the patient should have the power to influence prices and guide care, not this board. Beyond controlling Medicare, the Independent Payment Advisory Board's rationing edicts will serve as a benchmark for private insurance carriers' own payment changes. That's right. Although Mr. Waxman bemoaned the fact that private insurance would be part of Medicare, this thing will actually dictate the behavior of private insurances in this country. The board will have far-reaching implications beyond Medicare for our nation's doctors. Because of the limitations on what the control board can cut, the majority of spending reductions will come from cuts to Part B, the doctor's fees. Doctors will become increasingly unable to provide the services that the board has decided are not valuable. Is the answer to squeeze out doctors? Sounds like rationing to me. So, which sounds like the better option? Medicare bankruptcy and an unelected board deciding the care of Medicare beneficiaries, or doctors and patients deciding and defending the right of the care that they receive? The future of American health care should not be left up to this board, to this panel. It's an aloof arbiter of health care for seniors who depend on Medicare. I support the repeal of the Independent Payment Advisory Board. I'll just leave you with a quote from the American Medical Association. It puts our health policy and payment decisions in the hands of an independent body with no accountability. Major changes in the Medicare program should be decided by elected officials. For the American Medical Association, I yield.
Time of the gentleman has expired. The gentleman from California.
Mr. Chairman, I am pleased at this point to yield to my colleague from California, one of the key people in the authorship of the Affordable Care Act, George Miller, for 3 minutes.
The gentleman from California is recognized for 3 minutes.
I thank the gentleman for yielding. Mr. Speaker, I came to Congress in 1975, and since that time, I've been involved in the debate over national health reform proposals. Throughout these debates, lawmakers struggle with how to control costs without sacrificing quality care. Unfortunately, for decades, Congress chose to kick the can down the road while costs continued to climb and to soar. This trend ended with the Affordable Care Act. For the first time, Congress put in place specific identifiable measures that will make our health care system more transparent and efficient. This includes the creation of the Independent Payment Advisory Board. This board will be a backstop to ensure that federal health programs operate efficiently and effectively for both seniors and the taxpayers. We need to give these innovations a chance to work, because without these innovations there is little hope to get health care costs under control. 535 members of Congress cannot be, nor should they be, the doctors who think they know best of the practice of every medical field. 535 members of Congress are not immune to special interests that have a financial stake in the decisions that are made, not necessarily the best interest of the seniors, the taxpayers, or the delivery of medicine in this country, but perhaps in the best interest of their companies. That's why the Affordable Care created an independent board of health experts to make the recommendations to improve the system. It does not usurp the role of Congress. It simply acts as a fail-safe in the case government spending exceeds benchmarks. Under the law, doctors will retain full authority to recommend the treatments they think are best for patients. The law also prohibits the recommendations that would ration care, change premiums, or reduce Medicare benefits. In short, this independent board is about strengthening Medicare with evidence-based decision-making. Without innovative reforms like the board, Medicare's future will be put in jeopardy. Kicking this can down the road any further will only bolster those who seek to kill Medicare. We must strengthen Medicare, not end the Medicare guarantee. The Affordable Health Care Act strengthens Medicare, it extends the life of the trust fund, and has already lowered the cost for millions of seniors. However, without innovation, our current system will be unsustainable for our nation's families, businesses, and taxpayers. The Republican plan to end Medicare guarantee is no alternative. Innovation is the alternative, and I urge my colleagues to support the Independent Payment Advisory Board and reject this legislation.
Time of the gentleman has expired. The gentleman from Pennsylvania.
Mr. Chairman, I would much rather hear from some of our doctor friends who are speaking so eloquently. I have another doctor, member of the Health Subcommittee from Pennsylvania, distinguished gentleman, Dr. Tim Murphy. Yield for 2 minutes.
Gentleman from Pennsylvania is recognized for 2 minutes.
I thank the gentleman. Last decade, when I was a state senator in Pennsylvania, I took on HMOs and plans that made decisions by accountants and MBAs and not MDs. It was important to do that because we found that doctors could not make decisions even though they were supposedly empowered to do that. Instead, there was boards that would make decisions for them. And now here we are with deja vu all over again. We're about to have 15 presidential appointments, even under the advice of both chambers of commerce, both chambers of Congress. None of them are involved with medicine making decisions with regard to who makes decisions for you in terms of what gets paid and how much you get paid to doctors and hospitals. But as it goes through, what happens if there's a decision that says it's not going to be covered? Can you call the board itself? No. Can your doctor call the board? No. Can your hospital call the board? No. Can your member of Congress call the board? No. But in fact, it will take an act of Congress passed by the House and Senate and signed by the President to override that. So who is this panel and what decisions can they make? By law, it's people who are involved with finance, economics, hospital administration, reimbursements, some physicians, health professionals, pharmacy benefit managers, employers, people involved with outcome research and medical health services and economics. What's missing from that is any requirements that it might be people who have knowledge of such things as oncology, endocrinology, pediatrics, obstetrics, geriatric medicine, family medicine, surgery, and the list goes on and on. So in other words, what's going to happen here is not only if you don't like your doctor, you may not be able to keep it, but if your doctor doesn't like what is going to be covered, there's nothing that he or she can do about that. This is not the practice of medicine. This is the practice of government overtaking medicine. While Americans were begging for us to fix a broken system, what they got was $500 billion in new taxes, $500 billion in Medicare cuts, trillions in new costs, and massive mandates. 1,978 new responsibilities of the Secretary of Health, 150 boards, panels, and commissions yet to be appointed, and we don't know what's going to happen. We need to return health care to where it really is going to be fixed. And with that, I yield back.
Time of the gentleman has expired. The gentleman from California.
Mr. Chairman, I yield myself 1 minute.
Gentleman is recognized.
We're
for 1
talking
minute.
about the Independent Payment Advisory Board. Advisory Board. And the appointed membership of the board shall include physicians and other health professionals, experts in the area of pharmacoeconomics or prescription drug benefit programs, employers, third-party payers, individuals skilled in the conduct and interpretation of biomedical health services, ... These are people who will give us some recommendations, but they can't give us a recommendation to take away services. They can't give us a recommendation to impose more costs on the Medicare beneficiaries. And when they give us their recommendations, Congress can act on it. And if we don't like it, we can change them. I think we have the Republicans trying to scare people. They come in and say, Medicare costs too much. Well, if it costs too much, that's why we need this backup, to be sure that we're holding down costs. They say it costs too much, and therefore let's end it. That doesn't make any sense. I think the Americans should not be fooled. Mr. Chairman, I'd like to now yield to my colleague from California, the chairman of the subcommittee of the Ways and Means Committee, Mr. Stark, for 3 minutes.
The gentleman from California is recognized for 3 minutes.
Thank you, Mr. Chairman, and I ask unanimous consent to revise and extend my remarks tonight.
Without objection, so ordered.
I want to thank Chairman Waxman for yielding to me at this time. I rise in opposition to H.R. 5, brought to the floor by my Republican colleagues. It does two things. Repeals IPAB, as created in the Affordable Care Act, and it enacts a medical malpractice reform long sought by my Republican friends as a way to protect pharmaceutical companies, medical device companies, health care providers from any liability or full liability when they cause harm or death. The medical malpractice part of this bill is so bad that the California Medical Association rejects the bill and says to vote no unless they had a decent medical malpractice reform part in it. And when the doctors will reject medical malpractice reform issues, you know it's got to be bad. This extreme proposal is really not needed. I happen to agree with the part of the bill that repeals IPAB. We refuse to include it in the House version of health reform, and Congress has always stepped in its congressional manner to strengthen Medicare's finances when needed, and I see no need for us to relinquish that duty. We only have to look at the health reform law. It's extended solvency, it's slowed spending growth, it's lowered beneficiary costs, it's improved benefits, modernized the delivery system, created new fraud-fighting tools. We've done a good job. In fact, CBO projects that IPAB won't even be triggered until the next 10 years, proving that we've already done our job here in Congress of strengthening Medicare's finances. Today's Republican support to repeal IPAB isn't a sincere interest in providing Medicare for all. They still want to give us an unfunded or underfunded voucher, slash and burn funding, and despite my opposition to IPAB, it's far less dangerous to Medicare than the Republican voucher plan put forth in the House Republican budget this week. If IPAB doesn't undermine Medicare's guaranteed benefits and its ability to reduce Medicare spending, it has guardrails to prevent it. It doesn't permit costs to come from reducing Medicare and increasing costs on beneficiaries. It prohibits rationing and has annual limits on the cuts. The Republican voucher plan has none of these protections. The Republicans are continuing their march begun by Newt Gingrich to have Medicare wither on the vine, and I urge my colleagues to vote no on yet another political stunt which really, thankfully, is not destined to become law at this time. Thank the gentleman for yielding.
Time of the gentleman has expired. The gentleman from Pennsylvania.
Thank you, Mr. Chairman. I'd just like to take 30 seconds to respond to the distinguished ranking member before I yield to Mr. Bass. He mentioned that this so-called expert panel could have physicians, healthcare professionals. I refer him to Section 3403G of PPACA on page 423, specifically on majority for the panel. There's a specific prohibition that you can't have a majority of healthcare providers or physicians on IPAB. And as far as this being recommendations, you can't appeal, you can't sue this board. Only with 3/5 vote in both chambers with commensurate cuts can you overturn their recommendation. I yield 1 minute. The gentleman from Mr. Bass.
Gentleman from New Hampshire is recognized for 1 minute.
I thank my friend from Pennsylvania for yielding to me. Mr. Chairman, I rise in support of the bill consisting of two previous bills, tort law reform and a repeal of the Independent Payment Advisory Board. I wasn't here when the Obama health care, the Affordable Health Care Law was passed. Listening to the debate over the last half hour, you would have thought that nobody supported this bill. Of all the speakers we've had, I think 3 have admitted that they supported it then, and now you think it never existed. Well, any agency that's scored by CBO to save $3.1 billion is not going to do it by providing more services for seniors or innovation or preservation. It's going to do it by cutting payments to providers or cutting services to beneficiaries. It's as simple as that. And this is the beginning, or perhaps the core, of what represents a federal government takeover of health care services in this country. Sure, there may be a process whereby recommendations could go to the Congress, but instead of the relationship being between a patient and a doctor, it is going to be governed more by a federal bureaucracy that will make these decisions. I urge support of the pending bill, H.R. 5.
Time of the gentleman has expired. The gentleman from California.
Mr. Chairman, I yield myself a minute.
Gentleman's recognized for 1 minute.
We hear these things now, but we heard them in 1965 when Medicare was being proposed. Socialized medicine, an unfair government intrusion into our lives. Medicare is a popular, successful program. I support it. But the Republicans didn't support it then, and they don't support it now. The Affordable Care Act is an excellent bill. I proudly voted for it because as a result of that legislation, we're already seeing young people being able to get insurance up to 26 years of age on their parents' policies. We're already seeing seniors get help to pay for their prescription drugs. We are seeing insurance companies prohibited from the abuses where they put lifetime limits, and they're going to be stopped from denying people health insurance because of pre-existing medical conditions. This is good, and we're going to get even more benefits for over 30 million Americans when the bill is fully in place. It's a good bill. The Republicans would like to repeal it, but let's not forget they wanted to repeal. They didn't want Medicare in the first place. Mr. Chairman, now that I've used my minute, I would like to yield to the a member of our committee from the state of Illinois who has been very involved in helping seniors on all of these programs, whether it's Social Security or Medicare or Medicaid. She is very knowledgeable and highly respected, a little shorter than the podium, but I'm pleased to yield to her 3 minutes.
Gentlelady from Illinois is recognized for 3 minutes.
Thank you very much for yielding to me. I do ask unanimous consent to revise and extend my remarks.
Without objection, so ordered.
I hope the American people understand what's going on here today. H.R. 5 represents another in a long line of partisan political attacks on the Affordable Care Act. Since its passage 2 years ago, this historic law has been under attack. Today's bill would repeal the Independent Payment Advisory Board. The Affordable Care Act is replete with provisions to lower Medicare costs, from unprecedented tools to fight fraud to efficiency reform. The IPAB is a backstop to those provisions. When the Affordable Care Act does not do, and what the IPAB is prohibited from doing, is increase costs to seniors and people with disabilities or cut benefits. And that may be why my Republican colleagues don't like it. If you look at their proposal to take away the Medicare guarantee and turn it into a voucher program, you can see why. Instead of lowering costs for everyone, as the Affordable Care Act does, the Republican plan just shifts costs on the backs of those who can least afford it, seniors, disabled people, and their families. These are the same people who are harmed by the tort reform provisions, H.R. 5, federal intrusion coupled with a disregard for injured consumers. Instead of working to improve health care quality, as the Affordable Care Act does, H.R. 5 simply restricts the rights of patients harmed by dangerous drug companies, nursing homes, medical device manufacturers, doctors, or hospitals. I'm especially opposed to arbitrary caps on non-economic damages. Economic damages provide compensation for lost wages. Non-economic damages provide compensation for injuries that are just as real and damaging, injuries like excruciating pain or disfigurement, loss of a spouse or grandparent, inability to bear children. These arbitrary caps are particularly discriminatory for seniors and children who don't have lost wages. They're not worth much. H.R. 5, higher costs to seniors and disabled people, and fewer legal rights for injured consumers. It's a bad deal on both counts. Mr. Speaker, I yield back to Mr. Waxman.
Gentlelady yields back her time. The gentleman from Pennsylvania.
Mr. Chairman, at this time I yield 1 minute to another distinguished member of the Health Subcommittee, Mr. Guthrie from Kentucky.
Gentleman from Kentucky is recognized for 1 minute.
I thank the gentleman for yielding. Thank you, Mr. Speaker. I rise today in support of H.R. 5, legislation to repeal the IPAB and make critical reforms to medical liability system. The IPAB was created in the health care law as a way to contain growing costs, but the reality is those savings will likely be found by removing health care decisions from patients and doctors and place them in the hands of unelected and unaccountable bureaucrats. H.R. 5 also addresses the critical issue of medical liability reform. Our current tort system is driving doctors out of the practice of medicine. Those who remain are forced to practice defensive medicine, further increasing health care costs. The Congressional Budget Office has estimated that medical liability reform will save hardworking taxpayers over $40 billion. H.R. 5 makes two common-sense reforms to protect doctors and patients. I urge my colleagues to support the bill and yield back the balance of my time.
Gentleman yields back his time. The gentleman from California.
Mr. Speaker, may I inquire how much time each side has?
36. The gentleman from California has 36 minutes remaining, and the gentleman from Pennsylvania has 44 minutes remaining.
Mr. Chairman, at this time I'd yield 5 of our 36 minutes to the gentleman from Iowa, Mr. Braley.
Gentleman from Iowa is recognized for 5 minutes.
I thank the gentleman for yielding. Mr. Speaker, here we go again. My conservative friends are once more trying to take away rights of American citizens that are as old as the Declaration of Independence and the Bill of Rights. And they're doing it by talking about taking away the rights of patients without ever mentioning the word patient safety. This issue has been with us for a long time, and in fact, about 10 years ago, the highly regarded Institutes of Medicine did 3 studies on the issue of patient safety and the alarming cost it adds to our overall health care delivery system. The first of their studies was called To Err is Human, Building a Safer Health System, and on this cover it says, first, do no harm. The study concluded that every year up to 98,000 people die in this country due to preventable medical errors. And it also talked in this study about the cost of those medical errors. It estimated that the cost of failing to stop these preventable medical errors is between $17 and $29 billion a year. Now, if you multiply that over the 10 years of the Affordable Care Act, that means if we eliminated those errors, we would save $170 to $290 billion a year. So do we focus on patient safety and preventing medical errors? No. We focus on taking away the rights of the most severely injured, because that's what caps on damages do. They penalize those with the most egregious injuries and those who have no earning capacity. So who are those people? They're seniors, they're children, and they are stay-at-home mothers. They're the ones most severely penalized when you take away rights guaranteed in the Bill of Rights and the Declaration of Independence. So I oppose this bill in the name of the Tea Party. Not just the current Tea Party, but the original Tea Party, which was founded in opposition to taxation without representation. And if you go to Thomas Jefferson's Declaration of Independence, you will see that grievance against King George listed. And right below it in the Declaration of Independence is this grievance, that he has taken away the right to trial by jury. And that right was so important, ladies and gentlemen, that it was embedded in the 7th Amendment to the Bill of Rights. And it says very clearly that in suits at common law, which is what a medical negligence claim is, the jury gets to decide all questions of fact and no one else. Well, one of the most important questions of fact in a jury trial is the issue of damages. And my friends are trying to take away that right from the jury, the very same people who elected us to Congress, because they apparently think that Congress knows more than the people who sent us here, and who go into jury boxes all over this country in your state and listen to the actual facts of the case before deciding what's fair, including the all-important issue of what are fair and reasonable damages. So they're talking a lot today about defensive medicine. I want to tell you about the myth of defensive medicine. Every time a health care provider submits a fee for services, they represent that that medical procedure or that medical test was medically necessary. And if they don't make that representation, they don't get paid. Well, guess what, folks? If something is performed and billed as medically necessary, that, by definition, is not defensive medicine. Because defensive medicine is when you're doing something that's not medically necessary to protect yourself from litigation. So you can't have it both ways. You can't take the money and claim you're practicing defensive medicine. We also heard about the myth of setting these caps 30 years ago and never adjusting them for inflation. They always want to talk about the California bill that was passed in the mid-70s and imposed the very same cap in this bill, $250,000. What they don't tell you is if you adjust that cap based on the rate of medical inflation over that same period of time, the cap would now be worth almost $2 million. And that if you reduce that $250,000 cap to present value, those people in today's dollars are only getting the equivalent of $64,000 no matter how serious their injury is. And that's why I oppose this legislation, and that's why people who believe in the Constitution and in the states' rights under the 10th Amendment to decide what their citizens will receive as justice should be outraged that this bill is on the floor today. And with that, I yield back.
Time of the gentleman has expired. The gentleman from Pennsylvania.
Mr. Chairman, at this time, I yield to another valued member of the Health Subcommittee. 2 minutes. The gentleman from New Jersey, Mr. Lance.
Gentleman from New Jersey is recognized for 2 minutes.
Thank you, Mr. Speaker, and thank you, Mr. Chairman, for yielding. I rise today in support of H.R. 5 that combines the repeal of the Independent Payment Advisory Board with significant medical malpractice reforms that will help reduce health care costs and preserve patients' access to medical care. Today marks the 2-year anniversary of House passage of the President's health care law. During that debate 2 years ago, I joined members from both sides of the aisle in calling on the President to address one of the drivers of the high cost of health care by reforming the current medical liability system. Unfortunately, the President's health care bill passed the House on March 21st, 2010, absent any real or meaningful medical liability reform. The new law did include the Independent Payment Advisory Board, or IPAB, and this cost control board, made up of 15 unelected and, might I add, unconfirmed officials, has the power to make major cost-cutting decisions about Medicare with little oversight or accountability. The IPAB has been criticized by both Republicans and Democrats, and its repeal is supported by nearly 400 groups representing patients, doctors, and employers. Today, on the 2-year anniversary of the House passage of the health care law, we have an opportunity to move to the future and enact real health care reform that will help bring down health care costs that are escalating at unsustainable rates, while at the same time protecting needed care for our senior citizens. As a member of the House Energy and Commerce Committee, I am pleased to have the opportunity to work on this important legislation and urge all of my colleagues to support H.R. 5. Mr. Speaker, I yield back the balance of my time.
The time of the gentleman has expired. The gentleman from California.
Mr. Chairman, I'll continue to reserve our time. The
gentleman from California reserves his time. The gentleman from Pennsylvania.
How many minutes? How many minutes do you want? Mr. Chairman, at this time, I yield to another distinguished member of the Health Subcommittee, Dr. Gingrey, for 2 minutes.
Gentleman from Georgia is recognized for 2 minutes.
Mr. Chairman, I thank the gentleman for yielding, and of course I stand in strong support of H.R. 5, the PATH Act. Having authored half of the legislation, that is the Health Act, the Medical Liability Reform Act, but I'm also strongly in favor of repeal of IPAB, the Independent Payment Advisory Board created under Obamacare. We know, and our colleagues on the other side of the aisle, many of them know, that this was the most egregious part of this 2,700-page piece of legislation, which is now the law of the land. But what it is, Mr. Chairman, IPAB is their way of saving Medicare. I'll ask them time after time, what is your plan to save Medicare? They have no answers. All they want to do is continue to criticize our side of the aisle when we have meaningful, thoughtful plans to save and protect and strengthen, not just for these current recipients under the Medicare program, those who are seniors, those who are disabled, but also our children and our grandchildren. What do we get from this side of the aisle? From the Democratic side, we get IPAB. The language says no rationing, yet the provisions call for cutting reimbursements to providers, and eventually, without question, just as it has in Canada and the UK, Mr. Chairman, that leads to denial of care. And if that's not rationing, I don't know what it is. Let me, in the remaining part of my time, speak a little bit in regard to H.R. 5, the Health Act, the Medical Liability Reform Act. The gentleman from Iowa, the trial attorney, was just up here trying to imply that we would take away a person's right to a redress of their grievances if they had been injured by a medical provider or a health care facility because of practice below the standard of care.
I yield the gentleman another 1 minute.
Gentleman is recognized for 1 additional minute.
And I thank the gentleman. The gentleman from Iowa knows, in fact, that that is absolutely